Our case is Schmerber vs. California. Armando Schmerber was in an accident and was arrested for drunk driving. While receiving treatment for his broken leg and a fractured rib in a hospital, an officer ordered a doctor to take a blood sample. The blood test indicated that Schmerber had been drunk while driving. The blood test was the evidence introduced to the court. The question of the case was, did the blood test violate the Fifth Amendment guarantee against self-incrimination? The court's decision rejected Schmerber's claims of denial of due process, of his privilege against self-incrimination, of his right to counsel, and of his right to not be subjected to unreasonable searches or seizures. The plaintiff of the case was Armando Schmerber, and the defendant was California. The case was argued on April 25, 1966, and was decided on June 20, 1966.
The members of the court consisted Earl Warren, a Republican, Hugo Black, a Democrat, William Douglas, a Democrat, John Harlem II, a Republican, William J. Brennan, Jr., a Democrat, who wrote the majority opinion, Potter Stewart, a Republican, Byron R. White, a Democrat, Abe Fortas, a Democrat, Tom C. Clark, a Democrat. Representing for the petitioner was Thomas M. McGurran of Beverly Hills, California, and for the respondent, Edward L. Davenport of Los Angeles, California.
Hi, I'm Thomas McGurran. I am from Beverly Hills, California, and I am representing the petitioner, Armando Schmerber. At the hospital, the officer who had observed the petitioner at the scene inquired of the passenger of the car and talked with the petitioner and asked the petitioner whether or not he would be willing to take a breathalyzer test, to which the petitioner said no. The officer asked him whether or no he would be willing to take a blood test. According to the officer, the petitioner said yes, and the officer went out to obtain a doctor and a nurse. But when the doctor and the nurse returned, the petitioner then stated no, he would not take a blood test because his attorney had told him not to submit to such a test.
Attention, ladies and gentlemen. The Warren Court has decided in a 5-4 decision that Armando Schmerber be convicted on drunk driving counts.
In his majority opinion, Brennan concluded that the police did not violate Schmerber's Fifth Amendment right against self-incrimination because the extraction and chemical analysis of the blood sample did not involve even a shadow of testimonial compulsion. Justice Brennan held that the officers did not violate Schmerber's Fourth Amendment right against unreasonable seizures. Justice Brennan wrote that absent exigent circumstances, searches that involve intrusions into the human body require a warrant.
Dissenting opinions. All 4 justices wrote separate dissenting opinions. Justice Warren felt the decision broke the 14th Amendment's guaranteed due process of law. Justices Black and Douglas contended that the blood test did indeed force Schmerber to provide self-incriminating testimony. In a separate opinion, Justice Douglas also argued that the blood test violated Schmerber's right to due process as well as his right to be free from arbitrary searches and seizures under the Fourth and Fifth Amendments. Finally, Justice Fortas also disagreed because he believed the blood test amounted to self-incriminating evidence and a state cannot extract blood from anyone unless voluntarily allowed under the due process of law clause. I'm Liam Houchin. I gathered most of the information for the case along with Dylan, and I also worked on recording the video and editing it.
I'm Mike Korniak. I spent most of my time editing the video, but I also went around and found some information on the case.
During the project, I contributed a lot of information about the case. I found information on Schmerber himself and his life, and also did some videotaping.